One of the more troublesome topics in legal circles these days involves something called civil asset forfeiture. That might sound like a subject that would interest only lawyers, but our next guest will help us understand why anyone concerned about property rights should pay attention to the issue. Darpana Sheth is senior attorney at the Institute for Justice. She recently spoke about civil asset forfeiture with the Triangle Lawyers chapter of the Federalist Society. Thanks for joining us.
Thank you. Thank you for having me.
We're going to get into a lot of details, but first, for people who are unfamiliar with this, what is civil asset forfeiture?
Civil forfeiture is the government's power to confiscate property that's suspected of being involved in a crime. Now, it's different than criminal forfeiture that actually requires a criminal conviction. So unlike criminal forfeiture, civil forfeiture allows police and law enforcement to seize property they suspect of being involved in a crime without necessarily filing any kind of criminal charge, much less getting a conviction.
And does the property have to have anything to do with the suspected crime?
Yes, and so that's the link. There has to be some nexus or connection between the property and the crime. But the standard is very broad. At least under federal laws, for example, it's any kind of personal or real property that may have been used to, quote, facilitate a crime. And that facilitation language is interpreted very broadly by the courts.
That sounds like it could be very wide-ranging. Almost anything that's your property could be targeted for this.
Exactly.
Just how big a problem is this across the country?
It is a huge problem. So, for example, a very detailed report by the Washington Post, they did an investigative series, and in a 6-part investigative series, they found that law enforcement, state and local law enforcement, had seized over $2.5 billion from motorists on our nation's highways since 9/11, all without any kind of warrant or indictment. And that's just highway seizures. The same thing is happening at our nation's airports. And the third kind of forfeitures we often see are something called structuring forfeitures, which is where the government, especially the IRS and the Justice Department, have been aggressive about seizing bank accounts owned by individuals and small business owners because there's been a pattern of frequently depositing less than $10,000. And that's a crime under federal law because there's currency reporting requirements. And if you fail to comply with those, that's a crime. It's also a crime to try to evade those reporting requirements by purposely breaking up your transactions. But in these structuring cases, there's no evidence of any illegal activity. The only thing the government is relying on is a pattern of less than $10,000 deposits. And a lot of innocent people and small business owners especially have a very good reason for doing so. Their insurance policies will only cover cash losses up to $10,000.
Some people might be hearing us and saying to themselves, wait a minute, law enforcement officers are going after the bad guys, and this is just one tool they use to get these bad guys. Why is that not the right way to approach this?
Well, that's what criminal forfeiture is for. No one in America should lose their property without being convicted of a crime. And so the problem with civil forfeiture is really twofold. First, it has lower protections for property owners. So, for example, the standard of proof is very low. The government just, in order to seize property, simply needs probable cause to seize the property that is connected to a crime. Then the government only has to show to forfeit the property that it's more likely than not that the property is connected to a crime. And then the burden flips to the property owner, which is a complete reversal of our American presumption of innocence, to affirmatively prove that they didn't know about or consent to the illegal activity. And so these kind of procedures stack the deck against property owners because it's a civil proceeding. They don't have any right to counsel. And there's all sorts of less procedural safeguards that property owners enjoy. And the second reason is because civil forfeiture is not only easier for law enforcement to pursue, but it's lucrative to do so. In most states, in 36 or 38 states plus the federal government, law enforcement gets to keep the forfeited property or its proceeds and use it how it sees fit. And that creates a very direct financial incentive to seize and forfeit as much property as possible.
We are chatting with Darpana Sheth, who is senior attorney at the Institute for Justice. Does the problem vary from state to state? Are there some states that have a bigger problem with civil forfeiture than others?
That is true. Now, we've seen in the last couple of years a lot of states have enacted very comprehensive reform. So in the last 2 years, over 20 states, plus the District of Columbia, have really taken the initiative and passed comprehensive reform addressing these flaws. But the problem does vary state by state, and of course, each state has their forfeiture laws, and then there are federal forfeiture laws. North Carolina, for example, has very good forfeiture laws at the state level. The Institute for Justice issued a report it's a landmark study called Policing for Profit that grades every jurisdiction's forfeiture laws based on how well they protect property owners' rights according to the process, how much law enforcement will use forfeiture proceeds to benefit themselves, that direct profit incentive we were talking about, and the transparency, how accountable law enforcement is and how transparent these laws are in terms of their use of forfeiture and how forfeiture proceeds are spent. Now, North Carolina received a B+ for its forfeiture laws. It was very good in terms of protecting property owners' rights. For example, it only allows civil forfeiture when there has been a criminal conviction, except in racketeering cases, which is the exception. And it also does not allow law enforcement to benefit directly from forfeiture proceeds. Under state law, all forfeiture proceeds must go to fund public schools. Unfortunately, their transparency requirements are not as great, so it didn't get an A. But the problem with North Carolina and many other states is that even where the state laws are very protective of property owner rights, there's a big loophole called the Federal Equitable Sharing Program. Now, under this program, state and local law enforcement can seize property and team up with federal authorities to bring a federal forfeiture action, and in exchange get up to 80% of forfeiture proceeds. And this provides a very direct financial incentive for state and local law enforcement to evade their own stricter state laws in favor of the more lax federal forfeiture laws. And, for example, North Carolina takes huge advantage of this loophole. From 2000 to 2013, North Carolina took in $162 million in equitable sharing proceeds just from the Justice Department, and an additional $42 million from the Treasury Department's forfeiture program.
In the brief time that we have left, are there some reforms that North Carolina could put in place that would help protect property rights even more?
Yes, especially North Carolina. So it's already got the great state laws on the books. What it could do is prohibit the ability of state and local law enforcement to participate in the federal equitable sharing program, or at the very least require that equitable sharing proceeds, rather than going back to state and local law enforcement as it currently does under DOJ policy, those proceeds should go back according to state law to fund public schools, and that would remove the profit incentive. It could also increase its transparency and reporting requirements, so we know exactly how forfeiture is being used. For example, how many times are there criminal convictions, and is it really tied to criminal activity or not, as well as how the proceeds are used.